Don't talk to me, I don't believe a word. Don't try to make me feel alright.
This is the American Reckoning podcast, and I'm Paul. He's Aaron. So thanks for joining us. We're going to talk about the status of the Clarke County, Virginia War Memorial in Berryville, Virginia. So we have a lot to talk about there, and we'll get to that here in a minute. Just to kind of remind y'all that we have a YouTube channel and a Rumble channel. You can find us at American Reckoning on YouTube. So make sure you go on there and check us out and hit subscribe, because we got more of these coming up. We've got a bunch of episodes that we want to get to here in the next few months. Hopefully we're going to do a couple a month, but we all have to work for a living and stuff. So
right.
We'll try to get to it as best we can. What do you think, Aaron?
Yeah, man. They'll come along. They'll come along.
So we talk about Confederate heritage, Confederate history, the South, and a lot of the issues facing our Confederate ancestors in this crazy world of ours. And we always tie it back to what we think is an American reckoning that either needs to happen or is going to happen here soon. Hopefully, hopefully the rest of the world wakes up and doesn't just see that it's just the South is always picked on, and maybe they'll see the barrel of the gun started to be pointed at them,
right?
Which is the rest of the United States. But we tie it back because we see a lot of Marxism embedded in just about everything that is going on today. One of the topics we're going to talk about right now is the Clarke County Monument, which we call a war memorial because it is a memorial to soldiers who died in the so-called Civil War, quote unquote Civil War. We call it the War of Southern Independence. And they're Confederate soldiers. And the monument. So I'll go into a little bit about the monument, what it means, what it represents. And then we'll kind of talk about like who's involved in this thing, because there's an ongoing court battle right now, the Virginia Court of Appeals, that the Turner Ashby Camp, the Sons of Confederate Veterans, brought against Clarke County for the ownership of this memorial. And today in Fredericksburg, Virginia, this morning there was an arguments before the Clarke County, before the Virginia Court of Appeals by the attorney of Turner Ashby Camp, Sons of Confederate Veterans, and Clarke County, their attorney. So we're still waiting the results of that to hear what happened to that. But hopefully, you never know. We could actually hear it at the time that we're doing this podcast. But so I'll describe what the memorial is. So basically, and we'll show a picture of it. But basically, this is a typical Confederate soldier monument, standing tall. He's unarmed, and on the granite it's made of granite, and on that are words that talk about states' rights, that talk about why these men fought, and then it lists the names of the soldiers, the specific soldiers who died in defense of Virginia and Clarke County during the war. And they're members of the 6th Virginia Cavalry and some members of the 2nd Virginia Infantry and a few other unit soldiers represented. But basically what's happened is the memorial was, and this is all in the woke madness after the George Floyd incident in June of 2020. And sure enough, the problem is that in the wake of that, there are two major things happen. One is at least in the state of Virginia, the governor of Virginia at the time, Governor Blackface, that guy, the guy that used to dress up for Halloween like Michael Jackson or something. Thank God he's gone. But he allowed that there was some act, I guess, in the Virginia Assembly, if I'm correct, Aaron. I don't know. Correct me if I'm wrong, but that allowed local jurisdictions a chance to decide whether they wanted to remove monuments on public property, public land.
Right. So they left it up to the localities.
Correct. So that's in the wake of that, we have, of course, some pinpointed actions by a bunch of Marxists who must have been over this issue and started going around all over the South, wherever there was a Confederate monument, and started going like, I always hearken. They started crying out, that, oh, this is racist. The monument represents slavery. The monument, the Confederate soldiers were evil on the wrong side. And, the whole story. I mean, it's been going on for more than 3 years, but it really took hold right after that situation. Well, it came to Berryville in Clarke County. And it was from a man who all of a sudden one day decided that where this monument has stood for over 100 years, that it represented oppression, that it represented slavery, and all of this nonsense.
And he was the guy. I think I heard he was originally from North Carolina, so we're not talking about some northern transplant. And he was a guy who I think had former military experience as well. Not sure exactly what that was, but yeah, he'd been living in the county 3 years, and he decided that he was going to make an issue of it.
Yeah, and this is typical. This is typical of what started a purging, a genocide, if you will, a cultural genocide on steroids, focused on what the left, what the Marxists perceive as low-hanging fruit, which has always been the Confederates, the Confederates. And you have to remind people, hey, idiots, believe it or not, you may think that this is about the Confederates. They're coming after America. They're coming after the United States, and they'll come after the U.S. flag. They'll come after anything America. The Confederate is just a test bed.
Right.
Okay. That's how we look at this. And that's what it's bearing out exactly as you would think.
Yes.
So with the case of so Aaron's right. I mean, this guy basically, crybabied in the wilderness, and he's from North Carolina, doesn't even live in the county, not even from Virginia. And this was in sometime towards, I believe that date was sort of when the first cries came out from this dude, towards the end of the summer of 2020. And so the Clarke County Board of Supervisors decided to acquiesce to this and basically sucked their thumb and started to freak out. They had never even, let me make something really clear. This Board of Supervisors had no intention of doing anything to the monument, to the little piece of land around it, or to the grounds where it sits, which is at the courthouse in Clarke County in the little town of Berryville.
At least not publicly. And it was not an issue beforehand.
It's never been an issue.
Right.
From what anybody, in fact, and I'll get into it, they didn't even know they owned. They didn't even know they owned the property. They don't own it. They thought, I mean, they assume, I'm sorry, they assume that they own the property. Well,
Right.
come to find out that the property, the monument itself, and about a 25-foot circular grass circumference around that property is on private land. It's not owned by the county. So this was not known at the time. The Clarke County Board of Supervisors went to the Historical Society in Clarke County, and they asked them to do a little research, look into this, and produce a report that they can look over that gave them a little bit more information about the monument at the time, at the request probably of the county attorney. So that's what they did, and they also formed, the Board of Supervisors formed a committee, and this committee, they wanted to determine, what they were going to do with this monument. Well, one of the things that the Historical Society found out pretty early on is that indeed the county didn't own the monument or the ground.
Right. So who did?
So they started looking into the records and come to find out that it was actually owned by a little soldier, a little group of soldiers, not a United Confederate Veterans group, and not a Sons of Confederate Veterans, which wasn't in existence in the early 1900s. But in the early 1900s, it was actually owned by what was known as the Association of the Survivors of the Clarke Cavalry. And these were a group of veterans, Confederate veterans, who last were in existence back in, I believe it was 1916 or 1918, I think it was.
Right.
So that really put a total wrench into the county's plans, because they just assumed, oh, it's on the county courthouse grounds and we can do whatever we want with it. Well, no, not so fast. So they, through the public process, they had a hearing, a public hearing that they scheduled, and they have formed this. Go ahead.
Are you going to refer to the town hall here?
Yes, the town hall.
Right. So this was open to the public.
Correct. And let me back up just for a second. Just before they did that, in very short order, they also formed a committee made up of citizens and experts or whatever
that they picked, because several people in the community who were pro memorial tried to serve. And this is also really important because it begins to show the very, very pointed direction that this county was going in from the outset. But they denied two people on that board that were pro memorial, pro monument, were county residents that happened to be in the local Sons of Confederate Veterans, or at least had some real interest in keeping the monument for historical purposes, etc. And they denied them being on the committee. Anyway, so already they're trying to stack the deck in their favor. And you'll see this as I get into it. So this town hall, or public hearing, whatever, I guess it was technically, you're right, Aaron, it's called a town hall, occurred in March of 2021. And many of us were present. There was about, I would say, close to 100 people, or just over 100 people or so. Yeah, it was fairly well attended.
For a town hall. For a town hall, people don't usually come out for anything anymore unless critical race theory or something has completely screwed up your school system, and finally parents might come out. But for this, you don't expect anybody to show up except for a few crickets in the back aisle.
Right.
But there was actually 100 people there. 95% of the people spoke out in favor of keeping the monument exactly where it is, as history and as a testament and a tribute to those soldiers.
Right.
And they spoke eloquently. Everybody was given, I think, 3 or 5 minutes?
3 minutes. 3 minutes. 3 minutes.
3 minutes. And 3 minutes. And 3 minutes. And 3 minutes. 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 3 uh, and a lot of it's videotaped and everything. And some of the folks who were in the audience and the citizens speaking up had relatives on that monument. So it was very prescient and pertinent to them personally.
Which is exactly why the citizens showed up to talk about it. And Clarke County is quickly becoming kind of populated by new people coming in because the whole area is pretty popular, but it's still predominantly people who have connections, historical connections to the county in large part, even in the town. Yeah.
I mean, if you know Clarke County, you have the Blue Ridge Mountains and the Shenandoah River, which kind of separate the county from Loudoun County and the rest of Northern Virginia and Fairfax. So it's like this, but it's like an evil mist
kind of
coming over the Blue Ridge, all the woke, liberal, transitional people, transient types coming over the mountain. And so, yeah, you have that phenomena happening like daily almost.
Yeah.
So we have 95% of the people that showed up, and I'm not exaggerating. It had to be at least 95%.
Yes, it was overwhelming.
And then you had 4 or 5 people who spoke out. Well, they kind of wanted to keep the monument, but they wanted to move it out of the courthouse area. And then you had 2 people who outright wanted its destruction. They were, freaking cone head wearing weirdo liberals who just take it away, just like the movie Invasion of the Body Snatchers, where there's they freak out and whatever.
Yeah.
And then you've got these these committee members sitting on the stage and everybody's speaking, and I guess they seemed fairly, but you can almost tell the body language and seeing the situation that, as is many times the case, that they literally don't give a crap. That they sense that the game's already rigged, the deck's already stacked, and this is all for show, and it doesn't mean squat, right?
Well, a lot of them are local politicians, and a few of them are I guess you could say retirees who have no connection to the county. They moved in from other places. Northern places or other places, but yeah,
this is their big deal, man, to serve on a committee in a little town. It's like,
that's what a lot of people do, especially liberal people. They like to move into towns and they'll live there for a decade or so, and they're part of the community, and then they'll retire and from their whatever it is they did for a career and get into local government. Anyway,
so and let me back up just for a second, because I want to just real quick explain how this memorial came to be, and I sort of left this out a little bit. The Association of the Survivors of Clarke Cavalry, these veterans, went to the Virginia Assembly, the Virginia General Assembly, in 1886, and the Virginia General Assembly by act, not only created them, but created the means for them to build a monument for their fallen comrades. It says that in the language. They also made them tax exempt, as an organization, as it were, that would have existed today had they not died. And that they would then work with the Clarke County Board of Supervisors. I can't remember the exact language, but the mechanism was in place for them to do that. The Board of Supervisors, the Clarke County Board of Supervisors of that time, within several years after that, then deeded them the 25-foot piece of land on the courthouse grounds, right?
Which wasn't unusual, which was not unusual.
No, exactly. This is not necessarily uncommon at all. This was it
exists in a number of other, even to this day, it exists to a number of other counties in Virginia. And there's a reason for that. This is the place where all these people mustered when they went off during the war. And it was also the town meeting place. That's where the town got together. So the courthouse grounds was a very common place for this type of a public thing to be put as an expression of the community.
Yeah, and it was, and they looked at it even obviously back then as a memorial to their comrades.
Of course,
That meaning has not changed in 120 years, 125, 30 years. That's all it was. Just like they do up in northern towns and cities to erect for the dead of the Union dead. It's the same thing.
And you say 125, 30 years because of the time when this particular monument was erected.
Correct. So
Gotcha.
they then erected, they raised money. It cost them, they went to the UDC to help them raise money. They raised money themselves within, I think, 5 to 10 years. They finally have enough money. In 1906, they had a big, the monument was going to be erected on the land. They had 3,000 people come out in the little bitty town of Berryville for this ceremony. It was a big deal. They had a parade. They had all kinds of speakers, and it was a big deal. So the Veterans Association then, over the course of the early 1900s, and then finally in 1916 or 18, they had their last meeting before they died. And it's important to know that they wished that if they were to die and the organization become dissolved, that they're in their minutes that the Historical Society found, that they asked that the UDC, the Daughters of the Confederacy, go ahead and take over ownership and maintenance of it should they die off. That was their last wishes, which is a very similar organization to them at the time.
Well, right,
similar to the Confederate.
And technically, the Clarke County guys were not Confederate veteran guys, as far as Sons of Confederate Veterans goes. But of course, the UDC, they were the female counterpart to the Sons of Confederate Veterans. A lot of people could think of it that way, if they don't already know.
So, fast forward today. That's a little history on the memorial. Its reason, its purpose, its real meaning. The committee, so after this town hall, the committee then provided a short report and recommendation. And the recommendation was to keep the monument, but redesign, as the county, the board of supervisors use the word we hear a lot. It's called reimagine the grounds, which is
recontextualize.
Recontextualize, yeah.
Right.
Reinterpret. All of this is horse crap. It's basically changing. They wanted to, where they didn't before. They recommended redesigning it. So that's shortly after that, or within 6 months, the Turner Ashby camp, realizing that the board of supervisors, although they technically said that they could keep the monument, there is no way that any future board, as soon as some of these nitwits are elected off or voted off, eventually they're going to remove that monument, or that some future board is going to remove that, in anticipation of that possibility.
Well, and even currently it has not been well cared for.
Yeah, they haven't cared for it. They've just, I mean, there's damage at the base of it.
It's there's a lot of overgrowth that's damaging it, and a lot of other things going on as well. So, and we're not talking about maintenance, as you and I discussed earlier. We're not just talking about cutting the trees away, and sealing it up, and and all that kind of thing. They're talking about a very expensive, which I'm sure you're about to get to, overhaul of the grounds.
Yeah, I mean, so this whole reimagining and redesigning, recontextualizing, is what we now see as a boondoggle. But before that happened, what the Turner Ashby camp, the Sons of Confederate Veterans, wanted to do, and remember, the Turner Ashby camp makes nothing. They're a nonprofit. They accept donations and they have dues. They're a small organization, but their principal organizing purpose is to honor the Confederate ancestors, the Confederate dead, Confederate history, heritage, Southern heritage, which is represented in this type of monument and this memorial. And the Turner Ashby camp realized right away, this is much more than a monument. This is a war memorial to the dead.
Right. It didn't even list the living members at the time it was put up.
Right. It's purely for fallen comrades. This is
correct.
This is it's completely different. And Turner Ashby camp very early on pointed that out, which probably, I have to say, I think it probably influenced some of the possibly even some members of the board of supervisors to say, wait a minute, we can't just remove this. Let's just recontextualize it. Let's do the middle ground.
Right. Take that middle.
Well, the middle ground crap is going to cost, as we come to find out, they've already spent like $200,000.
Right, on designers and other things.
Designers and things like that, even though it's still under appeal, and I'll get to that in a minute. But the Turner Ashby camp in October 2021, I think, October 2021, they petitioned the court, the Clarke County court, to own the statue for the purpose of caring for it in perpetuity, to maintain it. It's a small circular piece of ground.
And this is on the basis of a Virginia law that allows them to do that. Isn't that right?
Correct. Yes. And what do you know anything about that law? I mean, basically it's in the Virginia code that says a similar organization or association, a corporation.
Right. This is on the basis that the original association that owned it, all the members died off, but they were never officially dissolved, and therefore none of their property was transferred to anybody else. So it's been sitting there in limbo ever since.
Right.
And so long that even the county didn't realize, so Turner Ashby camp came along and filed a petition with the court to take it over because they were a most similar organization.
Correct. And that is what the law says. The code, Virginia code, has a specific language that favors a similar organization, nonprofit, that can come in, that is most like the Association of the Clarke County of the Survivors of Clarke Cavalry, and that's the Turner Ashby camp. There are veterans in the organization. They are caring for veterans monuments, so it was just, it's a no-brainer practically.
Right. Well, and they're
but the county didn't want that. That is, certain members on the board of supervisors didn't want that. And what they did was they got the county attorney to intervene,
right,
in petition, saying that they had, under the auspice of the legal definition or legal claim of adverse possession,
right,
that because it was on county land, that nobody took care of it, and all of a sudden, like they didn't even know it. They didn't own it or whatever, that they should be the owners of it through adverse possession.
Sure.
And but the attorney for the Turner Ashby camp said, well, so the judge agreed with their motion to intervene in the Turner Ashby petition. And so then the Turner Ashby camp said, well, if we're fighting over the same thing, which is this monument and piece of ground, then the both of these cases should be combined in a civil court, where it can be decided by even a jury or something.
Right. It can be argued out with counsel for both sides and all that.
Right. Right. As you would expect, any matter where two parties are contesting over in essence, the same thing.
Right.
But in a strange thing, and this is where it gets weird, the judge decided, no, I'm denying your motion to intervene into the county, the Turner Ashby camp intervening and wanting to combine these cases, because they said that the Turner Ashby camp's case was not, quote, germane.
Right.
Germane
Very interesting language.
To the case. And everybody's like, what are you talking about? It's not germane. It couldn't be more germane. There are no legal. So, and some strange language, legal twisting. And this is where it starts in a span of just a few weeks and months over the winter of 2021 and early 2022. The court, the judge decided to keep the cases split. And not only that, allow the county's case to go forward first.
Even though they didn't file the original petition.
Correct. Even though the Turner Ashby camp originally filed in the first place, but the original petition. But then the Turner Ashby camp lawyer said, well, wait a second. We're going to intervene on that. That's incorrect. We're motioning to intervene in their situation, which of course the judge denied. So there's already 2 or 3 denials of the Turner Ashby. So then the county's case goes forward. And not only that, the judge allows them to pick their own jurors. 7. There's 7 jurors. The court case was set for March of 2022.
Right.
And Turner Ashby had no ability, no representation, or the Turner Ashby lawyers had 0 say in the case. They were out.
There was some type of court appointed representative, which had nothing to do with Turner Ashby camp. They were not, it was like a public defender, but it wasn't even one that was, had anything to do with the counsel that the camp had.
Yeah, it had, and he wasn't arguing on the merits of what the Turner Ashby camp's petition really was. He was really arguing on, basically,
right,
on the adverse possession situation that fits the county's favor. So predictably,
right, on their ground, in other words, they had to defend it on their premise.
Right. They had no reason to help the Turner Ashby camp.
Right.
And so this was a handpicked.
And the jurors were handpicked.
Pigeonholed.
Right. It's not like a normal jury selection process where both sides are there present to pick those who will decide.
Right. And the result, and this was all dictated by the judge's discretion to split these cases. So predictably, what happened was by a 7-0 decision, go figure, the county was awarded ownership of the monument.
Right.
Turner Ashby camp lawyers immediately filed an appeal, and the appeal went forward. So in the summer of last year, August 2022, the Virginia Court of Appeals actually agreed to accept the appeal, the case, and hear arguments.
Yeah.
The argument was scheduled for today, and they're still waiting to hear about the results of that.
Today being at the time we're recording this is March 30th.
Yeah, March 30th, and it was there's a three judge panel, and I guess you only need 2 of the 3 judges. The total argument time is 30 minutes. Each side gets 15 minutes. The Clarke County attorney also gets his time in court. So every step of the way, finally, the Turner Ashby camp gets some kind of day in court.
Right.
And I want to go through, and I think this is really important because this is important legally, although neither of us have any idea about much about law. But
especially at the appeals level, exactly how they decide it, how they vote, whether they do opinions or not at that level. We'll see.
Right. Oh, let me back up for a second because I think this is important. When the judge split the cases, remember, and allowed the county's case to proceed and go to jury trial, and then the trial resulted in April 2022, them being the county being awarded ownership. The judge then ruled that Turner Ashby Camp's case was now, quote, mooted.
Right.
It's now moot.
In other words,
So,
irrelevant.
Irrelevant.
Right.
You don't even get your day in court.
Right.
You can go on now. The case is over. Bye-bye. So unbelievable. That's not just bye-bye.
Yeah.
That's not justice. Bye-bye, bitch.
Yeah.
That's not justice. That's a crap show, man. So anyway, the appeal went forward. Go figure, because we weren't, the Turner Ashby Camp and everybody wasn't going to lie down. And thank God, because remember, this all costs money.
Yeah.
The camp has no money. Donations helped a little, but really,
sure.
You've got some
there is a lot of
you've got some amazing attorneys with some principle and some form of justice and right and wrong in the matter, who know about discretion from a judge and what they were doing. And you gotta hope, because this has much further ramifications than just this little memorial in Berryville, Virginia. This is not justice. This is not justice. So we'll see what happens. But I wanna flip over here real quick. I want to read just briefly the court appeal, and I bring this up because it's important to know some of these facts. Of when leading up to why the judge acted the way he did, and why Turner Ashby Camp is appealing the ruling and the discretion used in the ruling by the judge in this case. And so it says here, in a related case, Turner Ashby Camp, Sons of Confederate, filed on October 22nd, 2021, seeking an award of the ownership of that at the real property of the Confederate Memorial statue located in Clarke County. On December 7, 21, Turner Ashby filed its motion to intervene in the case of the civil action of the county, as had Clarke County in its motion to intervene in Turner Ashby's camp. And Turner Ashby argued that its claims to the subject of real property, including the Confederate statue, were germane to Clarke County's complaint. And here again, it's really important that the appeals court knows the language that was used in the original decision by the judge. So Turner Ashby filed its motion on December 7th to consolidate those two cases. The motion was denied, and the Clarke County Court also denied motion to consolidate the civil actions. Then March 9th, Turner Ashby tried again to file a motion to reconsider the order denying that motion, and that was also denied. 4 times this judge denied. And after Turner Ashby, the lawyers gave the judge time to reconsider, to think about this. He didn't care. The trial was set on April 8th, and as we mentioned, the final order came after the victory by the county. We believe, or the Turner Ashby's believes that the court erred in denying Turner Ashby's request to intervene in this civil action. Specifically, the Clarke County erred in denying Turner Ashby's the court denied Turner Ashby's initial motion to intervene, as well as subsequent motion for reconsideration. The proper standard of review, they go into some of that, the abuse, and here it is. This is the discretion standard that they're arguing today. whether it's legal or not. And I'll say, quote, the abuse of discretion standard requires a reviewing court to show enough deference to a primary decision maker's judgment that the court does not reverse merely because it would have come to a different result in the first instance. Accordingly, when a decision is discretionary, the court has a range of choice and its decision will not be disturbed as long as it stays within that range. It is not influenced by any mistake of law. And those are citing different law cases that came before. The Supreme Court has identified three principal ways by which a court abuses its discretion. First, quote, when a relevant factor that should have been given significant weight is not considered. Second, quote, when an irrelevant or improper factor is considered and given significant weight. And third, when all proper factors and no improper ones are considered, but the court, in weighing those factors, commits a clear error of judgment. Turner Ashby, and they go into describing the claim of Germain, the defense of Germain, and saying that that was incorrect that the court did, that the judge did in this case.
Right.
Though both Turner Ashby's claims and defenses were germane to the subject matter of the proceeding, the Clarke Circuit Court denied its motion to intervene anyway. This was error. The Clarke County Court's decision was an abuse of its discretion, its application of Rule 314, and that abuse of discretion harmed Turner Ashby. Turner Ashby Camp accordingly seeks redress of this court. Intervention and civil action should be allowed where them, and this is a situation that examples of germane, where the claim is germane to claims and defenses existing in a civil action. Intervention in a civil action should be allowed where the movement meaning the motion seeks to assert a claim, quote, germane to the subject matter of the suit. In this case, intervention movement, Turner Ashby did just that. It asserted both a claim and defenses, quote, germane to the subject matter of the suit. It cannot be clearer than that. So number two, germane, this goes into what really does germane mean? And I'll try to be brief, but I think it's important. Germane means relevant or pertinent. That's all it means.
Right.
They're connected. It makes sense. It's like proper. It's relevant.
Yeah.
It is so defined by Black's Law Dictionary. See Black's Law Dictionary, blah, blah, blah. And Virginia jurisprudence treats germane, quote, germane, to mean just that. Relevant, related to, or pertinent.
Right.
And then I'm not going to go into this, but he gives another example of the Supreme Court decision where the concept of germane matters in legislation, where germane is even used in legislation. As the Supreme Court wrote one day, those things, quote, those things are germane, which are in effect allied, relative, or appropriate. It is right. Its construction must be liberal. The fact, quote, the fact that many things of a diverse nature are authorized or required to be done in the body of an act is not objectionable if what is authorized by the act is germane to the object expressed in the title, or has a legitimate and natural association therewith,
right,
or is congruous therewith.
Congruous.
It's congruous.
It's a great. It's a great English
people, man.
That's a great English use of the term congruent, I think.
And so the attorneys argue, given the definition of germane, and even in the Supreme Court's application of the word germane, it is difficult to see how Turner Ashby's claim to the Confederate memorial statue in this case is not germane also to Clarke County's claim to the Confederate memorial statue in the case. Both parties seek the ownership of the Confederate memorial.
Right.
The only difference is that Turner Ashby sought ownership by virtue of a statute, while Clarke County sought ownership by virtue of common law claim of adverse possession.
Right.
In other words, the means to the claim may be different circumstances or different approaches.
But it's not clear that one's superior to the other.
No, exactly. That is a very good point, Aaron. Not one is over the other, so they're both, they're both equal and of standard. They both have a claim.
They have standing, in other words.
Standing, and
they should have standing.
But they're also standard types of legal claims to make. Right? One is an actual code of law. The other one, okay, you're using a common law claim of adverse possession, but it has been used. So they're both, the point is they're both valid in that sense. So germane is talking about what the object is they're fighting over. So anyway.
Right.
So he goes into what the court did. Second, the Clarke County states that the Clarke is not seeking the association's assets, which the Turner Ashby camp never sought specific assets of the previous association.
Except for this one.
That's what Clarke County saw.
Right.
Remember, the Confederate memorial statue was the previous association's only asset.
As far as we know, but yes.
Yeah, I mean, there could be something hidden underground somewhere. I don't know.
Yeah, who knows?
Third, the Clarke County Court identifies the issue in this case as deciding title of the Confederate memorial. That's exactly what Turner Ashby's petition sought. Title to the Confederate memorial in that little piece of land. Both Turner Ashby and Clarke County sought title and ownership of the Confederate memorial. So the attorney is making a claim. They're both fighting for the title of ownership of the same thing.
Right.
Their claims, though based on different legal theories, which we just mentioned, seek the same result.
Right.
Ownership of the memorial. The claims of Turner Ashby and Clarke County are germane each to the other.
Right. Yep.
The Clarke County erred in not ruling that Turner Ashby's defense was germane to Clarke County's claim. On that basis alone, the Clarke County Circuit Court should have permitted Turner Ashby's intervention. Turner Ashby asserted a defense to the Clarke County's claim of adverse possession. Turner Ashby was prepared to provide evidence at the trial on this matter that Clarke County is not entitled to assert a claim of adverse possession over the Confederate memorial and the real parcel on which it is located. It directly addresses Clarke County's claim.
Right.
Turner Ashby's defense to Clarke County's claim of adverse possession was not only germane, but if successful, would have defeated, and this is really important, would have defeated Clarke County's claim squarely on the merits. Remember, had we gone head to head, there's a whole lot more here in the background that we would have, that Turner Ashby camp, that the lawyers would have brought up as evidence.
Right.
Okay. Not only that, not to mention that you go right ahead, do not only on the claim and the Virginia Code, but hey, go ahead and ask the public, go ask the Clarke residents. We already know that probably 90% of them want the memorial to remain, and probably would, if the court would have done it right, they could have done a referendum.
Yeah.
A referendum to that effect. And it would have settled that pretty easily, which would have gone in Turner Ashby's favor. You think they're going to want to let the county own it?
At the moment, the vast majority of public outcry was, in favor of a positive sentiment towards the memorial itself. So, yeah, there's a good chance of that. Anyway.
Yeah. Conclusion. I'll just read the quick conclusion and I'll be quiet.
Go for it.
Clarke County Court failed to consider and recognize that Turner Ashby's claim of ownership of the real property and Confederate memorial statue was germane to Clarke County's ownership of the identical property. The Clarke County Circuit Court improperly, meaning the judge, considered and gave significant weight to the fact that while both parties sought ownership of the same property, they relied upon different legal theories. In so doing, the Clarke County Court abused its discretion and erred in failing to allow Turner Ashby's intervention in this civil action. Therefore, in consideration of the foregoing, Turner Ashby requests that, one, the court reverse the Clarke County Court's January 19 order denying Turner Ashby's motion, reverse and vacate the April 18 final order entered into this case, and which mooted, remember that April 1822 final order by the judge mooted or made moot Turner Ashby's case. And 3, remand the civil action to the Clarke County Court with instructions to conduct further proceedings with Turner Ashby being allowed to participate as a party defendant and counterclaimant. And number 4, for such other and further relief may be necessary.
Huh.
So basically, all Turner Ashby lawyers are asking is kick this sucker back and give Turner Ashby their day in court.
Right. Right.
That's it.
Yep.
So
yeah.
So
Yeah,
you can see that this has a lot to do with this thing called discretion. And you know what matters when a judge uses his discretion? I wonder what influences him, what knowledge he has, even in a small town judge. You know, you have to see the power sometimes or the consequences, I should say, of electing or appointing judges.
Yep. And some places they are
do
elected.
not see the balance. They don't see the good and evil. They don't see they pick and choose.
They do.
And that's what seems to have happened here.
They have discretion, and human discretion is always a problem, which is why the appeals process exists. You know, as we've discussed before, you know, people are going to be fallible, even judges, because even an honest-minded judge will have outside forces working against them, or, you know, working on them at least. Right. And you know, there are any number of cases where there are kind of, you know, good old boy politics going on, and that's what, you know, the appeals process and a lot of these elements of the legal system are designed to attempt to remedy. They don't always do it, but you know, in this case, at least Turner Ashby Camp has a shot.
Yeah. So we'll see how this pans out, but
right.
You know, this is the legal part, but also, you know, the political part, which allowed this Confederate monument removals to begin with.
Right. You're talking about are you referring to the modern political influence of a lot of people who really aren't culturally of the county, is what you're saying?
Yep. Yeah. I mean, just Confederate monuments being targeted purposefully.
Yeah.
They know that a lot of the governors, a lot of the jurisdictions or whatever, you know, they're purposely, and this gets back to, well, so you're saying that a Confederate, and again, you have the culture has to completely believe that the Confederates are evil, that the Confederates were slave owning, were white supremacists, were racists, were all of this stuff. And then it makes it easy. Then you can just point a finger and like, there's a Confederate monument. You better go take it down.
Right.
And then it starts,
and in other words, there's no other substance to the matter.
Right. It's over.
Right.
Yeah, you're evil. You've already been pigeonholed in your corner. Go suck your thumb and take it.
Right. You are forever tainted, and therefore there's no redemptive quality to your purpose, your existence, or anything like it.
So it's funny because I guess that what that means is me being white and you being white and us having Confederate ancestors and Confederate lineage or any ties to the South, because
right.
you could take it even further. We don't mean anything. In fact, like they did in South Africa, we're going to take your land.
Right.
We're gonna desecrate your memorials and monuments and graves.
Right.
And we're going to take the bodies and we're going to move them somewhere else.
Right. Yes.
We're gonna destroy your culture, your heritage, everything about you.
Right.
That's the real game that's coming.
Yep.
And put you under one giant equity blanket.
Right.
We're all the same.
Right. Yeah. Well, yes. And the problem is equity is outcome based. The problem with that has always been who are the arbiters of what constitutes equity.
It's not equality under law.
No,
it's equity. Equity meaning
what it becomes is dictatorship. It becomes dictatorship.
Tyranny.
Yeah. Yes. Oh, it is tyranny. I mean, dictatorship I mean, human beings,
Totalitarianism,
a lot of people have this
dictatorship.
idea that somehow we can have some type of benevolent dictator who will not act in their own self-interest, not act to protect the power they have, and not pander to supporting groups. I mean, this is completely irrational with any knowledge of the human condition or human history. So
yeah, so it's frustrating.
Yeah.
But it also takes people to not fear, that Confederate flag on your mic, or that little pillow with the Confederate.
Well, yeah, people assume it has a
people
meaning
are so
that
terrified.
This is a battle flag. All right, this is a battle flag. This is a flag that soldiers used during the war. Okay, this isn't a symbol of white supremacy or anything like that. A lot of people might say it is like by default or something like that, or indirectly. That's not valid.
Yeah,
I
but
reject
they
that.
own slaves, Aaron. They own slaves.
Most of them. First off, most of them didn't.
Right. What's the percentage? Like maybe on the order of 96%.
I mean, yeah, it's extremely low. A lot of people don't realize that. Well, as far as actual ownership goes, I mean, people can see the census numbers and see how many slaves there were in the South and say, wow, 4 out of every 5 people must own slaves. And that's completely untrue. Most slaves were actually, and there were huge numbers of freed men in the South, huge numbers, because it was legal for them to be around and freed. But that's a story for another day. But I would like to define boondoggle, because I love that word. So I've got the definition of it here. Hold on.
A boondoggle is what we describe the Clarke County Board of Supervisors is doing, and this giant redesign, reimagining, whatever the hell they're doing.
Right. Well, it's a noun. It's a thing, and it's described in this is I think, what is this, Webster's? It's dictionary.com, but they still have a pretty good definition. It's the first definition is a wasteful and worthless project undertaken for political, corporate, or personal gain, typically a government project funded by taxpayers.
Imagine that. The Yankees were real good at that, right?
Still are
during the war and after the war, during Reconstruction, and they're real good at it today. They are perfectly suited for boondoggles.
Yep.
And all the Southerners and all those evil white supremacist Southerners, all they want to do is just leave us the hell alone.
Well, you know what? A lot of other types of people are affected in that way too. And,
right. You don't need to be a Southerner. You can just be a conservative who wants limited government and doesn't see. There's 2 types of people in this world. I always say it: those who want to be governed or want to govern others, and those who want to be left the hell alone.
There are strong tendencies in both those directions. I agree.
So
yeah, absolutely.
Well, hey, I get all emotional and crazy, but hey,
no, that's your job on this, man. I think you're doing great.
Hey, let's go ahead and end this here. We'll pick up some other episodes here as we go along in the coming weeks here. But thank you for joining us. This is American Reckoning Podcast again. Go ahead and subscribe to us on YouTube or Rumble at American Reckoning. And remember, we're not a bunch of white supremacists and racists and I don't know
any of that.
Hell, the left and weirdo people want to think, because look into it. I mean, you'd be surprised.
We love America. We love America.
Yeah, we do. Hey, imagine that.
Yep.
We still think there's a chance. That's why we call this American Reckoning.
That's right.
All right, y'all take care. Appreciate it. We'll see y'all next time.
All right, buddy.
I have nightmares, don't have a